Welcome to the Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program, as we tell you, has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide information and resources that'll help you decide whether or not you want to contact a lawyer. Perhaps in some cases you'll be able to handle some issues yourself. If you do decide that you need professional counsel, you'll be better prepared, and so will the professional who you select. Our goal, of course, is to help you achieve the best possible results while saving time and money. The Bazar and Associates law firm in East Providence continues to lend their time, energy, expertise, and support to this program. And we, as we say, want to welcome and thank Attorney David Bazar. So in our last segment, we talked about car accidents, the personal and financial costs. So today, the financial payouts of not only car accidents, but other personal injury issues that bring you to the table of those kinds of payouts. We're going to address the most common questions and provide some answers to what you need to know about the lawsuits, the settlements, the strategy behind those claims, and then the settlements afterwards. What do you need to know about how much, and what to do with it? So there's a lot to cover there. So let's begin, David. Last segment, as we were saying, we talked about car accidents, but there are other torts, I guess they call them, that entitle people to financial payouts for personal injury. Want to tick a few off so we know who to give heads up to?
So there are a number of different ways you can get injured. You can get injured in a slip and fall accident where typically you might go to a retail establishment, a grocery store or another store, and we've had many, many cases like that where someone goes into, say, a grocery store and there's something on the floor that should have been picked up but hadn't been picked up, and you, as a result, slip on that, a grape or a banana peel on the floor. There are cases where you might get injured going to somebody's house where there's not adequate lighting or handrails or something to protect you going up and down stairs, or the stairs themselves are in a state of disrepair, so you can get hurt that way. We've talked about medical malpractice cases before. That is really a personal injury. Products liability cases, excuse me, where there are products that are defective that cause an injury, and all of the types of claims that can go into that.
So all of those things could bring about some sort of a claim. Personal injury usually first taps into insurance companies. So car accidents, people in some states have mandatory, and that's might be the first trigger. We started to talk about how an adjuster is usually the first person who gets involved. You may say at times, call the lawyer, and some just and only want to deal with a lawyer. So what happens, before we get into the dollars and cents of all of this, when someone deals with an adjuster? There are things people should know about the adjusters. Who does the adjuster work for, and what should we watch out for?
So there can be some very nice adjusters, but they don't work for you. They work for the insurance company. And as nice as they may seem, their job is not to give you as much money as you're entitled to, but to save their employer, the insurance company, as much money as they can. So yes, they're going to contact you. That's what they do. And I would advise my clients to very nicely inform them, please call my attorney and deal directly with my attorney. Because there are things you can say that may not be phrased exactly correctly that can be used against you. There are things you can tell them that may not be exactly pertinent that can be used against you. So rather than take a risk of saying anything that can hurt you, let your attorney speak to them.
In researching this, it was interesting to note that obviously while an adjuster would need to know about cars and car repairs and what those things cost, also that person is likely to Google that plaintiff, that victim, so to speak, to find out dirt, as they say, or what could be wrong with it, or what else might lead you to think that it wasn't entirely just and only the other person's fault. And they're doing quite a bit of digging, which I guess corroborates your thought, which is you better call a lawyer, because who would expect that someone does that when something, you slipped on a banana peel, that was clearly not my fault, but they're looking to see how to offset whose fault it was and pay less.
So there's a number of things that they're going to do, actually. Some that will look directly at the liability and determine whether or not there's any comparative negligence? Did you, as the person who got injured, do anything that contributed to the accident happening? Yes, they'll do that all the time. In the old days, they had these indexes. So they would take your name and your social security number and they would run through these indexes of prior claims to see if you've made claims before. The reason they do that is to determine whether or not you're someone who's prone to make these claims, or did you have a prior injury and the injury is very much related to the new injury and therefore reduces perhaps the value because you never stopped treating from that injury. They still have those indexes, but they go well beyond that now. They'll go on and look at your Facebook and say, what are you doing? Oh, you went to this concert, you did that. Oh, look at that, you're involved in that 5K run or whatever. How can you be injured? And so they'll be looking at things like that as well.
And a few other things. It makes sense to me that they might want to know, they want documents. I had an x-ray, so here's the x-ray bill. Certainly makes sense. But in addition to that, they might want other medical records, other proof of earnings and tax returns. So whether someone is represented by a lawyer or not, are they entitled to look at someone's tax returns?
So let's talk about all of those things. They want, need, and require, so they're entitled to, your medical records from this particular accident.
Yes.
Because they need to see what your treatment was,
Yes.
how you progressed, how it affected you, what you could or couldn't do. So they're going to get that. They may be entitled to records from prior injuries, especially if they're to the same part of the body that's injured in this accident.
That makes sense.
Records for wages. So the easiest way to prove your loss in a case where you have a job and you can't do your job as documented by the medical records as a result of the accident is through a letter from your employer showing, well, here are what the records show she made or he made the 13 or 26 weeks prior to the accident, and this was her salary, job, and position. Couldn't do the job, this is how long he was out for, and this is when he or she returned. And that's pretty solid documentation. But not everybody has a job that you can look at in that form or fashion. For example, you might be self-employed. What do you do for work? Do you have a tax return? Does the tax return reflect what you made prior to the accident and what you couldn't do as a result of the accident? Perhaps that's a way to get at it. So the tax returns could become relevant. Not necessarily. The first example I gave, you wouldn't need the tax returns. What about somebody who had a job but hadn't been working their choice for other reasons, but could otherwise work, but now can't work because of the accident? That person has a lost earning capacity. Again, it's something that they may be compensated for, but how do you prove that loss? You may have to go back several years with tax records to show what you did and what you earned and what you're capable of earning. So those are a number of different reasons why some of that documentation may be relevant in something that you would provide to the insurance company. Now, tax returns can be very voluminous and have a lot of other information, and there may be some information in there that's not relevant. The attorney can cull through that and say, okay, you're not getting, for example, the returns on my real estate investments that are in here because they have nothing to do with this claim or my capacity to earn money because it's a passive investment, so to speak. The money just comes in and I report it on my taxes. So not everything may be relevant, but some of it very well could be.
And if someone decides that they want to go it alone first and figuring that they can settle with the insurance company, you have opinions about that, but nevertheless, that person who's in the accident is still required to secure or go after those archives and produce that information, and otherwise they'd still have to do it if they were working with an attorney. Either way, they'd have to access those documents. Does that end up putting someone at a distinct disadvantage when we know that most of the time people want to go to settle versus going to court, takes less time, et cetera, et cetera? What's going to drive that, David? How does that work?
Well, the example I just gave of somebody who has lots of different forms of income,
Yes.
they may provide something that they think, all right, sure, take all of this. And the insurance company may see something in there that said, oh, you do have rental income. Do you collect the rents? Are you able to go out there? Do you do the repairs to the real estate? So you may be opening up other issues unnecessarily that the insurance company can try to use against you, even if it's not something that should actually be used against you. So unless you're an attorney representing yourself, which is still a bad idea, you really should hire an attorney.
Sounds right. And so when it comes to filing a lawsuit, we find out that maybe somebody could do that themselves and they're going to a circuit court, right? Is that what it is?
Well, it depends where you live. In Rhode Island,
okay.
it would be Superior Court.
Superior Court, okay.
If you're appealing from the U.S. District Court of Appeals, you go to a circuit court.
And with the best of them, having the ability to negotiate a settlement, the insurance is going to likely offer its lowest bid first. Who wouldn't? That's smart. Yeah. You think that you're pretty savvy. You want to go back and negotiate a settlement. Online, there are places that someone can check off or tick off a list of the kinds of things that you could use to help corroborate your side of what you think you should. But it seems that those can become very unwieldy. That's mostly why someone would want to get involved with a lawyer. Now, when you know that insurance is the first thing that kicks in, how do you determine if someone is underinsured, uninsured, whether or not you even find that it's worthwhile to take the case?
Yeah. So, a couple of things there. I've had many clients come to me who've tried to handle a case on their own, and they say, you know, I'm a really, really good negotiator.
Yes.
Okay, well, that's great. However, being able to negotiate the price of a house that you're buying or something else really is based on the fact that you have some knowledge as to what real estate's worth, you know what you're willing to pay, you know what other houses have sold for.
Comparable value.
You have comps. You have an ability to know the arena in which you're playing. So you have an automobile accident and you're injured and you're severely injured. Well, do you know all the rules? Do you know what the insurance limits are for the person who hit you? Because you need to know those limits, because they may not be, this is the second part of your question, they may not be enough to cover your damages. So when you negotiate, did you send a letter to the insurance company to say, I want your policy limits, and now that you know the policy limits, I want you to pay your policy limits? And if you don't pay, under a Sermley versus Allstate, you're going to be liable for all of my damages, no matter what your policy limits are, because I'm putting you on notice in accordance with that case, that if you don't negotiate with me in good faith, that your policy limits no longer are in effect and you're going to have to pay me whatever a court says my damages are. You didn't send that letter? Well, there, you've lost a lot of leverage in your ability to negotiate what they should pay you, because you've given up a big chip that you could play against the insurance company because you're not a lawyer. You should have a lawyer. If you are negotiating to settle for the policy limits, did you put your own carrier on notice for your uninsured motorist coverage? Because it's not only uninsured motorists, it's UIM underinsured motorists, and they may be liable to pay whatever the balance of your damages are in Rhode Island. If you didn't do that, then they may not have to pay you, because you need their permission to settle with the tortfeasor before you settle with the tortfeasor. If you don't have that permission, then they can say, you didn't protect our rights and we're not going to pay you another dime. So there's a lot.
You certainly have a heavy stick when it comes to both the experience and obviously the legal information that most wouldn't have readily available anyway.
And my point is, there's a lot more that goes into the negotiation than just being a good negotiator.
So even if someone uses a lawyer, enlists a lawyer, there are certainly some distinct advantages in you wanting to, and your client wanting to, settle out of court versus going to a jury trial. So review some of those. One thing that crosses my mind immediately is get it over quickly.
There's some advantage to that. Obviously, the sooner the money is in your pocket, the better it is in your pocket than the insurance company's bank account. No doubt about that. And oftentimes, where a case isn't worth the policy limits, so to speak, and it's a gray area as to what a case is worth sometimes, you get to a range. And when you get to that range in evaluating the case, and I'm going to just make up a case in numbers, but let's just say the case is worth $20,000 to $25,000. And
you didn't pull that out of your head. Is it not true that that is a typical payout, somewhere $24,000? I read places
well,
about
25 is a typical policy limit in Rhode Island.
Okay, that's where that came from.
20 is a typical policy limit in Massachusetts. So I took 20 to 25, partly because of that, because it keeps you out of the, I need to get the last 25,000 because my case is worth more than that, so I can go on to the next policy. Because you can't negotiate, if your case is worth 40 and the policy limit's 25, you can't negotiate to take 20 and say to the insurance company, give me the 20, and I'm going to go after the other money from my own carrier because you didn't exhaust the limits that were available to you from the first carrier. So we're going to use 20 to 25. The policy limit is 25, but your case is barely worth 25. It's probably closer to 24. So they offer you 22. Now, here's the thing, and insurance companies will do this a lot because they'll save $1,000 or $2,000, maybe. Is it worth going to court for that last $2,000? It very well may be. And if it's the difference between 23 and 25 and you have a possible claim over that, it's definitely worth it. But if it's a difference of $2,000 and it's, after a fee and everything, much less in your pocket.
After your fee.
After our fee.
Of course.
And then after the costs of going to court to get that money, it may not be worth the difference. And oftentimes my clients, after we go through the benefit and cost analysis, might say, I'll take the 23, I'm fine with that, and I get it now, as opposed to the expenses of putting it in suit, going through the depositions and the aggravation and all of the other process to get the balance of the money. So smart insurance companies will try to nickel and dime you a little bit, but if the case is worth what the case is worth, and it's much more than that, and the upside is much greater, you're always better off putting it in suit. If the upside is not that great, it's a cost-benefit analysis. And
part of your job, as I understand it, is to determine whether or not this is really something that needs to be pushed further along.
Yeah, always. And sometimes clients will say, just like the insurance company is trying to make a point and save $1,000, the client will sometimes say, even if it costs me money, I have a point too. And so you have to go back and forth and determine whether or not it's really worth it for them to make that point. Sometimes it is, because sometimes it's not about the money. Usually it is. Usually it is.
But to your other point about it not being about the money, how do you deal with, for example, a client who comes to you and says, that guy is in the wrong. I don't want to settle, which means he won't have to admit guilt. He may have to pay, but he won't admit guilt. But somebody wants to, on some high moral ground, have someone be taken to task, made it proven, signed, sealed, and delivered that there is guilt, and you don't think that there's wisdom in that. How does that impact on whether or not you'd either A, want to take the case, and how you might proceed with the case?
So, depending on the type of case, you're 100% right. If the damages don't warrant it, you're going to probably tell the client that I'm not going to do that case because I'm not going to waste my time and your money because the client would have to pay. And I wouldn't put up the costs in a case where I think they're making a mistake like that. So it's going to be their money and their time. And usually, let's just say the liability's clear, so I might put the money up, but it's coming out first. So I'm wasting the client's money in the long run. And I might tell them it's not worth it if the damages don't warrant doing what they want to do. However, there have been cases, which are somewhat in the nature of personal injury cases, where the wrong is so egregious. And we're not talking about auto accident cases usually. You might be talking about a case against the government for some egregious wrong civil rights violation that they committed against your client, where there is a reason to proceed. There have been cases against DCYF for some very horrible things that happened. DCYF has been vindicated on some of them, but some of them, they need to be brought so that some of what's going on can be brought to light. And it's not always about the money in those kinds of cases.
So when you do have to take someone to court, or even if it doesn't go to court, someone has to pay for, what is it, an expert witness, the deposition time, travel, or whatever else. There are a lot of expenses involved with this. Do you flesh all of that out with a client to help them decide how many things they have to subtract against what is a potential bottom line?
That's absolutely what you have to do. For example, in a wrongful death case going to trial, you may have already hired an economist to give the earning capacity of the decedent so that you can value the case. But then the cost of having that expert come to court in a trial is got to be factored in. You may have to bring in the doctors to show what happened and what pain and suffering there was, and the cost of those expert witnesses has to be factored in. There may be, in the case of someone who is severely injured, a life care plan that had to be done to determine what the cost of the care is. If you go to trial, that person has to come and testify, and there's an expense to that. So those cases where there's a death or severe injuries, there is a higher upside. So you have to determine then where you are on the continuum of what the value of a case like that is worth. So, and we've had these cases. So we had a case where a woman was severely injured, quadriplegic, and our life care plan came in, and all the pain and suffering and damages and all the losses suffered by the family, loss of consortium and society and companionship, factoring all that in. What is that case worth? Well, we thought it was worth $5 million, maybe even a little bit more. The policy limit was $6 million. They offered $3 million. Is it worth it to settle for $3 million when you had to go through all of this? No. So on the continuum, our evaluation was there's a strong likelihood that we're going to get more money than has been offered. Even after the cost and the expense and the aggravation, it's worth going forward. Then they offer $4 million. Is it worth it to go forward? Yep, the upside is still much higher. The cost even factored in make it worth going on. Then they get to $5 million. Is it worth going? Well, at $5 million, the upside's now only $1 million, which is a lot of money.
Sure.
But there's also a downside because the jury could come in at a lower number than they've offered. So now there's risk in play. You have to factor in the risk of a higher number versus the risk of a lower number. And now you can factor in the costs, expenses, and aggravation. So maybe at that point, that case is worth settling.
And how about another layer yet? How about the fact that there's, with that kind of money, my guess is, don't they automatically, doesn't the defendant automatically hit the, I'm going to appeal story, which takes longer, more costs, less money, less likely that you're going to have money that you need to take care of whatever you lost because of all of this?
Yeah.
So there are still more layers to lump
Well,
on
and how
top
about
of this.
factoring this? Give me the $5 million now, let me put it away and start earning interest and accumulating. And if you get a pretty good rate of return on that money, and you're talking 2 or 3 years down the road, how much of the potential extra money that you would have gotten after the costs and expenses have you already earned back? So that's another thing that you can factor in at that point in time. And again, a case like that, it's going to be a structured settlement because the money is needed over time, and there's a good advantage of, for young people, you have to almost always structure it to protect their money for them for the future. I'm talking about under 18. And for severe injuries, there's oftentimes a good reason to structure that money as well.
So let's explore that in the time that we have left. I know that you'd spoken earlier about medical costs. There are things that they call general damages, the things that you know that you can absolutely put a number to, and there are things that are softer.
Right, so
it's the other way around.
Reversing it, special
damages versus general.
Right.
So there are these listings that you go through, and apparently there's even an online calculator. Not that I would ever trust that was something that matters that much, but if our viewers should know that that is an option. Nevertheless, if you win, there's the issue about, okay, now it's time to collect. How does that happen, and what should one do? You started to mention the structured settlement, but if you've had this going on for a year, 2 years, you want some money right up front. How do you decide how to take portion up front, structure? How do you talk to someone about that, David?
All right, so just going back to that example I gave about whether to settle, there is another factor, which is the interest rate in Rhode Island on a judgment is 12%. So that's a strong factor in the other direction, because you're not going to get 12% on your money. But how much of the aggravation to the going through the process does that offset once you subtract out the percentage of interest you can get? So in that particular case we talked about, we took the money. We set aside money outside of that for use of things that they needed to do, redo the house, obtain a vehicle, so that the woman could be
Okay.
and all of the things that they needed. And it was a very large sum of money. And then the balance of it went into the structure so that there would be money in the future to pay for caregivers to come in, to pay for updates to the buying a new vehicle down the road, to having money for other medical concerns or conditions that might come up down the road. And so that money gets put away. And it gets put away tax-free because it's a personal injury case. A personal injury case, when it's settled, there's no tax on that, no income tax. And in a structure, if it goes into the structure before you get it, so you don't take it and invest it, but the insurance company puts it directly into the structure, the interest and growth of that is also tax-free.
Taxable.
Tax-free.
Tax-free.
Tax-free. So you take that and all those advantages and the ability to get your life back and on course, and you're never going to be, put back to the condition you were in, but at least you can start trying to move your life forward. All of those factors come in. And so in this particular case, the money's put away and it's there. And when you structure something like that, it's a lot of money. So you structure it so that there's a guarantee that you get back at least what's put in. And then in this particular case, it's structured for the life of the person who was injured. So that money's never going to run out. They're always going to get that money.
So I assume, even though you are a bright lawyer, at some point, do you bring in immediately a tax accountant so they know how to deal with it? And when people have questions about, I'm taking Social Security, how does that factor in? What gets taxed? How much is interest? What part of my pain and injury is taxable? Do you need to call in an accountant right then and there to decide that, David?
Well, actually, first for the structure, you use a structured settlement expert. And so in the old days, insurance companies used to like to do the structures themselves without even telling you what they were going to put into them. You're entitled to know what you're settling for and what's going in. But they would use their own internal insurance annuity company to write that. So they were getting premiums on that and making money on both sides. There are independent agents out there that can price them with all different companies and get you the best company and the best rate of return. And so we work with a person who does that and knows what he's doing and has been doing it for years. And then on the accounting side, sometimes you need that, but not always. It depends on the situation.
Good to know. It seems like we could almost do a whole section on that. We hope that this has been helpful to you, car accidents, personal injury issues. We think that it's important that you get to know these things. Stay tuned to Law Matters, because the law matters to you.